Very good evening, students. Good evening, everyone. Any volunteer, please confirm about the voice and the video in the comments. Very good evening, Priti. Chaliye. I hope everything is fine, the video and the audio. Okay. On that note, let's begin with this class. So first of all, I welcome each one of you to my class on the mock test of criminal law. Let's start with my brief introduction first. In case if you don't know my name, it's Sandeep Khatri. These are my areas of specialization, as you can see on the screen: the constitutional law, criminal law, commercial law, family law, jurisprudence, and law of torts. Students, I have also shared the link of my profile on Unacademy, so make sure you follow that to get all the updates about my special classes and my plus courses. I have also shared the link of my Telegram channel where you can connect with me and ask questions in relation to your judicial preparation. There is a code. My code is Khatri10, which you can use to get free access of all the special classes available on Unacademy app. So this was about me. I request everyone now please be attentive, and this is going to be an interactive session. So today we are going to have some MCQs on criminal law, CRPC, IPC, and evidence. And here comes the first question on your screen. Who among the following is not entitled to claim maintenance under section 125 CRPC? Choose the most appropriate option. Sumati, first one to answer correctly, that is C, followed by Preeti, and yes, C, unmarried sister is the correct answer. Student, section 125 CRPC is basically states talking about the concept of maintenance. Okay, so who will give the maintenance and who can claim the maintenance, right? So the correct answer here is unmarried sister. So in short, the brother is not liable to maintain his unmarried sister as far as section 125 is concerned. Under CRPC, if there are two or more courts who have taken cognizance of the same offense and the question arises as to which of them ought to try that offense, the question shall be decided. Now, who is going to, decide that question? First option, Supreme Court. If the courts are subordinate to the same High Court, by that High Court. If the courts are not subordinate to the same High Court, by the High Court within the local limits of whose appellate criminal jurisdiction the proceedings were first commenced. Now, choose the most appropriate option. Namaste, Ladli. Megha Mohan, first one to answer correctly, followed by Ladli and Sarah Khan. Everyone's answer is B, and yes, students, B is the correct answer. So both these statements, the second and the third one, is correct, and Supreme Court has nothing to do with this situation. The FIR can be quashed in the exercise of inherent powers by who can quash the FIR? First one to answer correctly, Megha Mohan, followed by Sumati and PK Law School. Yes, C is the correct answer. And okay, Sumati, you have answered both C and B as well. So C is the correct answer. Okay, that is the High Court. Now I have some interesting associated questions with this concept. And the first one is there any specific section mentioned in CRPC where it suggests that High Court can quash the FIR? Is there any section on this concept? Yes, please. Is there any section which suggests that High Court can quash the FIR? Meghna Mohan, if you are answering 482, so basically 482 is the inherent power. Okay, under inherent power you can quash the FIR, but there is no such specific section which specify the concept of quashing of FIR. Okay, so the answer is there is no such section, but yes, under section 482, which is basically inherent powers of the High Court, and by the use of that power, the High Court can quash the FIR. Now coming to the next question in relation to the same concept, and that is, can High Court use inherent powers in contravention of expressed provisions of CRPC? I'm repeating myself. Can High Court use inherent powers in contravention of expressed provisions of CRPC? Yes, please do answer in the comments. Okay, Meghna Mohan, again, first one to answer, followed by Sarah and Ladley. Okay, no. And yes, the answer is correct, students. No, which means High Court cannot do something which is in contravention of the express provisions. Okay. Vineet Raman, you have answered yes. The correct answer is no. Okay. Chaliye. Moving to the next one. In which of the following cases the prosecution witness was prosecuted for perjury? I think this is one of the most famous case law, by the way. Sammy Gill, followed by Ladley and Preeti. Yes, A is the correct answer. That is Jessica Lal case. Okay, so it's one of the most landmark judgment. There's a movie as well on this. No one killed Jessica. So the correct answer is A. Okay. One additional information, students. In case if you don't know about Priyadarshini Mattu case, make sure you read that case. That's very, very important when it comes to the concept of Indian Evidence Act. Okay, it's a landmark judgment again. Next, in camera trial refers to. What do we mean by this term in camera trial? Ladli, Sarah Khan, and Preeti Singh, top 3 students to answer correctly. And C is the correct answer, students. Okay. So a trial to which public and press are not allowed. Do not just get yourself confused by the name of this concept, in camera. So in camera means your public and the press are not allowed. Only certain persons who are associated with that case will be allowed. Examination of accused by medical practitioner at the request of police officer. This is under section. Top 3 students to answer correctly. Sammy Gill, followed by Sarah and Shushri. Yes, B is the correct answer, students. The correct answer of this question is section number 53. Now I have one more question in association with this. Can anyone tell me what is the difference between section 53 and 54? In both the sections there is examination. Okay, so what is the difference? What is the difference between section 53 and section 54 of CrPC? Okay, Sammy Gill, counter question to you. If you are saying 54 is of arrested person and section 53 is of accused, then what is the difference between these two? What is the difference between accused and arrested person? "54 on the request of police." Okay. 54 may at the request of arrested person. See, there is a major difference. There's a major difference. Anything else? Anyone? Come on. It's not that difficult. So should I answer? Okay. Okay, Preeti. Now let me give you the answer. See, when you will read section 53, 53A, and 54, in all these three sections, there is a common thing first, and that is examination is taking place. Fine. Now coming to what is the major difference between 53 and 54? The major difference is in the objective of the section. Now the question is why examination is taking place under section 53, and the purpose of that examination is to collect evidence, which means under section 53 the examination of accused is taking place so that we can collect evidences from his body, his or her body, right? Now coming to section 54, what is the objective of section 54? The objective of section 54 is this is basically the right of an arrested person, and the purpose of examination is so that we can assure that he is the arrested person is healthy enough to stay in the police station, right? So that is the major difference between these two examination. And when it comes to section 53A, that is of basically you're accused of a rape. Okay ji? So that is 53A. I hope it's clear now. Chaliye. Now moving to the next question. By the way, there is one more question which we can ask at this point of time. Under which section there is examination of victim of a rape? And there is a recent landmark judgment as well in relation to this, by the way. Please tell me the section number where the rape victim, is examined. 164A. And recently there is a landmark judgment. Anyone can recall a landmark judgment in relation to the examination of a rape victim? Dinesh versus. Wonderful. Okay. And recently a judgment has been passed that your two-finger test has been held invalid. Okay. Next. What is the period of limitation of filing a suit to establish the right over the property attached by a person other than the proclaimed offender who has filed claims and objections to the attachment? We are doing questions from the CrPC, and the first line of this question is the period of limitation of filing a suit. So yes, this is again related to CrPC only, by the way. Yes, PK Law School, completely correct. Two-finger now held unconstitutional. First one to answer correctly of question number 7, Ladley, followed by Nawab and Preeti. Yes, everyone's answer is correct. That is of 1 year. Now let me give you the conclusion of this question. This question is actually about if a person has been declared a proclaimed offender. Now in that case we are going to attach his property. But if if there is any objection, if there is a claim of someone else over that property, then that person can come to that court. But what if that court reject that specific claim and objection? In that situation, he has still 1 year of time period to file a fresh suit in a court of law, because it's again a kind of a matter related to your property. So that is why the correct answer is 1 year. Next one. Claim referred or objection made within the period allowed under section 84 of CrPC in the event of the death of the claimant or objector be continued by. So what if if the person died, then who can now claim on behalf of that person? Only one student has answered correctly till now, and that is Raja Shekhar. Raja Shekhar, followed by Sami and Advocate Sucha Singh. Yes, C is the correct answer, Ji. So the correct answer is his legal representative. Okay. The powers, duties, and liabilities of a receiver appointed under section 83 of CPC shall be the same as those of a receiver appointed under. I think it's an easy one. If you have read it even once, you can easily recall the exact section number and the clause as well. It's an easy one. Okay. Meghna, Raja, and Sami. Top 3 students to answer correctly, and everyone's answer is correct. Rest. Done? Section 202 of CrPC 1973 deals with. This was not that difficult, and it's an important section. Sara Khan, first one to answer correctly, followed by Advocate Sucha Singh and Preeti. Top 3 students to answer correctly. That's D, postponement of issue of process. Okay. Now, can anyone tell me what is the objective of section 202? Why the magistrate is postponing the issue of process? Anyone? What is the objective of section 202? Yes, please do participate. It's not that a difficult question. Section 202 is one of the most important section number. Investigation, no. Nawab Khan, your answer is somehow, to some extent is correct. Okay, now let me tell you this. See, now listen carefully. I'm answering this question. What is the objective of section 202? So see, the examination of complainant take place under section 200. Once the examination has been done, now the magistrate can be either confirmed that there is no such, the complaint is completely baseless, then the magistrate will dismiss the complaint. First, now coming to the second point. If the magistrate is satisfied that yes, there is a case, the complaint is genuine and there is no doubt about the complaint, then the magistrate will initiate the process of issue of process. Okay, dismissal is under section 203, issue of process is under section 204. Now coming to the last and the third point. What if the magistrate is not sure about dismissal of the complaint or about the issue of process? In that category, the magistrate will use section 202 and postpone the issue of process. That is basically 202. I hope now everyone is clear with this. Okay. Next. A declaration of forfeiture under section 95 of CrPC can be set aside by. Who can set aside? It's a direct question. If you have gone through with section 95, you can easily answer. Nawab Khan, followed by Sara Khan and Sami Gill. And everyone's answer is correct. That is D, High Court. A direct question, and I don't think anyone is committing mistake in that. Moving to the next one. See, this one is an interesting question. We all know section 28 and 29 is very, very important for your exams. But, this is just a new perspective to ask this question. So to, get you confused, I have intentionally asked this question. So according to which section, so basically not only section, the clause as well. According to which section of CrPC, assistant of session court may pass sentence? Yes, please. This is one of the best question which can actually test, how far you can recall your language of the Bail Act. First one to answer correctly, Sarah, followed by Ledley and Raja. Yes, C is the correct answer. So if you can recall that, I think it's wonderful. It's wonderful. And by the way, there is nothing मतलब like 24/4. Okay, 28 D तो कुछ है भी नहीं. ठीक है. Next, according to which section of CRPC protection of members of armed forces from the arrest? The question is incomplete. Protection of members of armed forces from arrest. Starting from Sami, Gil, everyone's answer is correct. Manorma, Raja, Mohit. Yes, C is the correct answer. That is section 45. Okay, answer this one, students. Which section under CRPC states or clarifies this concept that CRPC has nothing to do with Army Act, Navy Act, or Air Force Act? Which section? Which section of CRPC states that CRPC has nothing to do with Army Act, Navy Act, and Air Force Act? I don't think this is one of the difficult questions. You can easily answer that. क्या बात है? I have got the answer. Sunita, correct answer. Section number 5, saving clause, clarifies that. And similarly, is there any section, is there any similar kind of section is available in IPC as well? If you can recall that section as well from IPC. From IPC, I am asking now. Which section number from IPC? Okay, 5 only. Perfect. So IPC section 5 as well, confirming that. Now the last question in association with this concept. So suppose if a person from armed forces, if that particular person committed an offense like murder, so that person will not get the punishment because IPC will not be applicable, CRPC will not be applicable, so that person will not get the punishment. Answer in the comments. Yes. Yes, if he is on official duty. Rustam Bawari case. Milijan. Students, answer to that question is that person will get the punishment, but under Army Act or under special laws related to defense. So IPC and CRPC will not be applicable. Okay. And in some circumstances, even IPC and CRPC can also be applicable, depending upon various factors. Next. Joining of two or more independent and respectable inhabitants of the locality in which the place is to be searched is the mandate under. First one to answer correctly, Nawab Khan, followed by Ladli and Raja Shekhar. D is the correct answer. Everyone's. Warrant of arrest shall be in such form as prescribed in. Sunita, followed by Preeti and Ladli. B is the correct answer. Anjum and Sammy Gill, please do correct your answer. B is the correct answer. Okay. See, when it comes to CRPC, there are there are two schedules. Okay. So schedule number 2 is basically talking about forms. And what is the total number of forms available? What is the total number of forms available in schedule 2? Sunita, correct answer. 56. Okay, 56 is the correct answer. And the most repeated question which you will get in your exam is the first one is, what is form number 1? That is basically deals with summons. What is form number 2? That deals with warrant. And which one is the largest form? Which one is the largest form in the whole schedule? Yes, anyone? Largest form. Largest form number. No, Sunita, it's 32. It's that, yes, it's 32, and that is related with the charge. Millie Jan and Preeti Singh, completely correct. Section 61 of CrPC deals with the provisions relating to top 3 students to answer correctly. First one is Manorama, followed by Sara and Sammy. D is the correct answer. Everyone's answer is correct. Anjum, please do correct your answer. Section 67 deals with service of summons outside local limit. In a non-cognizable case, when a magistrate orders the police to investigate in that it will be at par with the cognizable offense case, and the police will have all the powers in respect to investigation. Now, just complete the sentence, okay? Police will have all the powers in respect of investigation, and then choose the most appropriate option. Nawab followed by Sunita and Sammy. B is the correct answer. PK, please do correct your answer. B is the correct one. Everyone's answer is correct. Rest. Okay. Okay, tell me the section number. Tell me the section number from where you have answered this question. Tell me the section number. Sunita, completely correct. PK, yes. Section 155. Occurrence report in CRPC is under section. Occurrence report. First one to answer correctly of question number 18 is Sunita, followed by Sarah and Sammy. Yes. D is the correct answer, students. Section 157 deals with the concept of occurrence report. Now, can anyone tell me the formula of occurrence report? Formula in the sense कि what actually, is inside the occurrence report. What is inside occurrence report? Anyone? Yes, please. Map of the site? No. Absolutely no. PK. Anyone else? It's not that difficult. If you have gone through with section 157, you can easily recall. Details. See, Advocate Sucha Singh, obviously there are going to be details in any report. Okay, if there is a medical report or a legal report, right? So what kind of details? That is the question. Scene of offense. No. Okay, now let me give you the formula. Okay, there is a formula. What is occurrence report? And trust me, if you are not able to answer this question, what is in the occurrence report, then I think you have no idea what is the objective of occurrence report because of obvious reasons. Now, listen this. Occurrence report means first there is going to be copy of FIR, which means there is going to be copy of FIR. Plus, in addition to that, there is going to be a statement that whether the police officer is investigating the case or not investigating the case. And if the police officer is not investigating the case, then what are the reasons for not doing the investigation? I'm repeating myself. What is inside the occurrence report? First, the copy of FIR. Second, whether the police officer is investigating or not investigating the case. If the police officer is investigating the case, that's more than sufficient. But if not investigating the case, then what are the reasons for not doing the investigation? I hope now everyone knows what is occurrence report. Now coming to the second question. What is the objective of occurrence report? What is the objective? Why do we have the concept of occurrence report? Now, answering to that question, if you can recall, under section 154, we can lodge the FIR and there is no need of permission from the magistrate. When you go to section 156, the police officer can start the investigation without telling the magistrate. So it means the magistrate has no idea that some FIR has been lodged, whether the police officer is investigating or not. But after only occurrence report, when he got the occurrence report under section 158, 157 is occurrence report, 158 is how you transfer that report. Now, because of section 158 only, the magistrate will get to know, okay, someone has lodged this FIR and now the police officer is investigating or not investigating. So, to bring magistrate also into the picture, that is the purpose of occurrence report. Okay, I hope now everyone is clear with that. Done? Advocate Gurpreet, you are asking, sir, ADA का एग्जाम कब तक आएगा and passing marks कितने चाहिए? So you are basically asking about the exam कब आएगा. तो see, the due date is pending since long, so you can expect it in the upcoming 3 or 6 months. ठीक है? So this is how it is. Okay, if you see, there is no fixed date unless and until there is notification from the official website. Till then, all what it is complete rumors. Okay, so the thing is, but yes, what we can expect is within 3 or maximum 6 months you can expect the exam. So answer to your first question. And the second one, the passing marks. So Haryana ADA is, I hope it's 100 marks exam. So target at least minimum 90. I think last year the cutoff was somewhere around 84 or 85. So your minimum target should be somewhere 90 from the general category I'm talking about. Okay. Next one. Which of the following states that no appeal shall lie from any judgment or order of a criminal court unless otherwise provided? One of the important section related to the concept of appeal. Sunita, Ledley, and Sammy. Top 3 students to answer correctly, and everyone's answer is correct this time. Yes, Anjum, Sara, Preeti, Ankita, and Manorama. Correct answer. So it's a direct section based question. I don't think you need any kind of an explanation for that. Section 39 and 40 of CrPC makes it mandatory to give information regarding commission of certain offences. Such information can be given to whom? Magistrate, police officer, or C or D? First one to answer correctly, this time Ankita, followed by Sunita and Ledley. C is the correct answer, and everyone's else answer is also correct. Now some questions from the IPC students. Some questions from the IPC. A person is stated to be partially in capex under section 83 if he is aged. Okay, top three students to answer correctly: Sami, followed by Sunita and Mohit. Everyone's answer is correct. That is A. Nawab Khan, you have answered C. Above 7 years and under 16 years. No. Absolutely no. One of the most famous maxim from IPC. What is the meaning of this maxim? Actus non facit rea nisi mens sit rea. Okay, everyone's answer is correct. There can be no crime without a guilty mind. Okay, can anyone tell me, is there any exceptions to this rule? Is there any exceptions to this rule? Are there any exceptions of this maxim? Give me some examples. Public nuisance, bigamy, abduction. Good. Kidnapping is also one of the good example. Next. Irresistible impulse is a defense. Top three students to answer correctly: Ladley, followed by Preeti and Blossom sisters. D is the correct answer. Sunita, please do correct yourself. Irresistible impulse is not a defense neither in India nor in England. And in case any one of you, if don't know what do we mean by this term irresistible impulse means, when you got angry and that person goes completely out of control. Okay, one of a funny example can be of the Hulk. Okay, the Hulk. Okay, the moment he got angry, he goes out of control. So that is basically irresistible impulse. So when it comes to chapter number 4, section 76 till 106, there is no such exception of irresistible impulse, because if you cannot control your anger, that is basically your problem, not ours. So you will get the punishment for irresistible impulse. Okay. The defense of consent is not available in cases of. The defense of consent is not available in cases of. Ladley, Shivangi, Preeti. C is the correct answer. Mohit, Please do correct yourself. B is not the correct answer. C is the correct answer. So if you are causing someone grievous hurt, okay, you will get the punishment of grievous hurt. The consent is not going to save you. If your case falls under section 87, 88 or 89, then consent may save you. Criminal conspiracy is an agreement between two or more persons to choose the most appropriate option. Top 3 students to answer correctly: Millie, Sammy, and Ledley. Manorma, please do correct yourself. B is the correct answer. Okay, just read section 120A, the language of section 120A, and you will know how B is the correct answer. Top 3 students to answer correctly: Ladley, Sarah, and Shivangi. Yes, D is the correct answer. It's completely a case of extortion. Ladley, Preeti, and Sammy. Everyone's answer is correct. That is D, which is basically no offense. In the case of sentence of death, power to suspend, remit, or commute is conferred upon Monica, Preeti. Correct answer. And Ibrat Zahan. C is the correct answer, students. When it comes to commutation, it can be done by the appropriate government, and appropriate government can be state as well as central government. So C is the correct answer. Okay. When the offense is punishable with imprisonment as well as fine, maximum term of imprisonment that can be awarded in the default of payment of fine shall not exceed. Advocate Sucha Singh, followed by Manorma and Ladley. B is the correct answer. That is 1/4. The offense of theft becomes robbery when it is And yes, everyone's answer is correct. Starting from Ladley, Semi, and Sarah. B is the correct answer. Manorma, please do correct yourself. I'm talking about robbery, not dacoity. If there was dacoity, then the answer is committed by 5 or more person. If we are talking about theft becomes robbery, the correct answer is coupled with imminent danger to life. Now some 5 questions from Indian Evidence Act. Oral evidence under section 60 of Evidence Act may be direct only, hearsay, both A and B, either A or B. Starting from Sami, Ladli and Jyoti, everyone's answer is correct. That is A is the correct answer. Direct only. Under section 45 of Indian Evidence Act, the opinion of expert can be the question of Indian law, foreign law, both. Only A, not B. Monica, Sara and Ibrat Zahan. Correct answer. Students, please do correct yourself. When it comes to section 45, there is a list that has been given and Indian law is not in that list. So the correct answer is foreign law. B is the correct answer. Okay. Section 27 of Indian Evidence Act applies to yes, B is the correct answer when the person giving information is an accused and is in police custody. Alibi is governed by plea of alibi. D, section number 11 is the correct answer. For conduct to be relevant under section 8 of Indian Evidence Act, it Vikas Sharma, first one to answer correctly, followed by Sami and Preeti. C is the correct answer. Now, anything which you are not clear with, students, you may ask. This is the link of my profile, my Telegram channel, and this is my code Khatri10. So let's crack PCS J with Unacademy. Students, one important announcement. If you have not enrolled yourself till now, make sure you do that as soon as possible for the All India Judiciary Scholarship Test. And you can stand a chance to win exciting prizes. And you can win up to 100% on your Unacademy subscription. The test is on 13th of November at 11 a.m. And this is completely free of cost. You don't need to pay anything for this. Okay, so it's kind of a win-win situation. You are preparing yourself for your judiciary examination, so make sure you subscribe for this test. And if you perform well, you can win exciting prizes and scholarships. Anything, students, if it's not clear to you, you may ask. And if it's all done, I'll conclude the session. I hope these sessions are helping you in your preparation and you are learning something new. On that note, that's it from my end. See you in my next class. Till then, yes, it's time to say peace.